Well, good morning. This is John Neerman, and it is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 12th, 2020. The time is 9:30 a.m., and I'll begin with the roll call. Good morning, Commissioner Lindley.
Good morning.
And good morning, Commissioner Janeka.
Good morning, Chairman.
And Ms. Smith, are you there?
I am. Good morning.
Good morning. And how about our Public Interest Counsel? Mr. McWhorter, are you there?
Good morning, I'm here.
Good morning. Well, I'd like to remind folks to keep their phones on mute when they're not speaking, and I'd also like to remind anyone who's here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov. Include your name, affiliation, and the item number that you'd like to comment on, and we'll do our best to accommodate that request. For those who are making presentations, please wait to begin until I or our General Counsel have asked you to begin speaking. And remember to check that your line is unmuted before you speak. Turning to our agenda, item 1 is going to take quite a bit of discussion, I anticipate, and our agenda is otherwise relatively light. So we're going to take up item 1 at the end of the agenda following the petitions for rulemaking. And Ms. Smith, I'll ask you to please call item number 2.
Item number 2 are the applications by Citgo Refining and Chemicals Company LP for amendments to TCEQ air quality permit numbers 3123A and 9604A. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those that have signed in on this item will be noted for the record.
Thank you. For the benefit of those who are not familiar with our process, we have a 2-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has met those requirements, we then consider which issues are appropriate to refer for hearing. So the first part is about who gets a hearing, and the second part is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can have standing if they name at least one member who would have standing in his or her own right and raise issues that are both germane to the organization's purpose and relevant to this application. And colleagues, here we have a single request by Citizens Alliance for Fairness and Progress in Corpus Christi. It's clear to me that the Alliance has met the requirements for a hearing. The Alliance's request is germane to the organization's purpose. It identifies members who have articulated personal justiciable issues and who are affected differently from the general public, really by virtue of their proximity to the proposed or the existing facility. Turning to the issues, and again, for the benefit of those who are not familiar with our process, we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. So to put that another way, they have to be within our jurisdiction on this type of application. And one example of the limitation is we can't, for example, consider economic impacts such as effects on property values. So I would organize the request into 5 referred issues, and the issues I would identify are as follows: whether the draft permit is appropriate in terms of the applicant's compliance history, whether there is compliance with the required control technology, including BACT and MACT, whether emission estimates and modeling are complete and accurate, whether the emissions will adversely affect the requester's health or the use and enjoyment of their property, and whether the draft permit permits are adequate to determine compliance. So that's my view of the one party. I would grant the request and the 5 issues that I would refer. Commissioner Lindley, let's start with you. How does that all sound to you?
I'm in agreement on everything you said, and I would also propose, if I make the motion, that we do refer the matter to ADR as well.
Great. And what about a hearing duration?
I would propose 6 months, the standard time frame.
Makes sense to me. Commissioner Janetka, what do you think?
I'm in agreement as well. I had some consideration that I gave to the length of time frame in terms of this being a slightly different hearing than what I think the established norm is. There's slightly different dates on the determination of what parties are affected, but I agree with you that given the relevant statutes, the one protestant requesting the contested case hearing, I agree, are an affected party, and those were the same 5 issues that I've identified, and I think you've described the parameters of those issues. I'm also comfortable with the 6-month duration. Would be ready to move forward on it.
Great. Well, I'll entertain any additional thoughts or a motion.
I can make a motion. I move that we grant the hearing request of the Citizens Alliance for Fairness and Progress in Corpus Christi, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling process. We refer the matter to SOA for a contested case hearing on the following issues. A, whether the applicant's compliance history warrants additional terms or conditions in the draft permits or denial of the permits. B, whether the proposed facilities demonstrate compliance with requisite emission control technology, including applicable back to max requirements. C, whether the permit applications contain inaccurate or incomplete emissions estimates and air dispersion modeling. D, whether emissions from the proposed facilities will adversely affect the requester's health or normal use and enjoyment of their property. And E, whether the draft permits include adequate and enforceable provisions to determine compliance. And that we specify the maximum duration of the hearing, 6 months from the preliminary hearing to issuance of the proposal or decision.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janetka?
Aye.
And I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is consideration for approval to publish and solicit comment on 2 draft total maximum daily loads for indicator bacteria in Corpus Christi Bay beaches, Cole Park, and Ropes Park of the Nueces Rio Grande Coastal Basin. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Karen Eamon with the Water Quality Planning Division in the Office of Water. With me today are Chris Loft with the Total Maximum Daily Load Program and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is requesting the release for public comment of 2 total maximum daily loads for indicator bacteria in Corpus Christi Bay beaches, Cole Park, and Ropes Park. The TMDL covers 2 assessment units in 1 stream segment within Nueces County. A stakeholder group was formed with balanced representation of all interested parties and was tasked with providing input on the TMDL document. The development of this document included an active public participation effort and balanced stakeholder group coordinated by the Texas A&M University Corpus Christi Center for Coastal Studies. The success of this project is due to the collaborative effort of the individuals and organizations that put in the time to develop this document to improve water quality in their community. The Executive Director respectfully requests approval to publish the total maximum daily loads for public comment. Thank you, and we are available to answer any questions that you may have at this time.
Thank you, Mr. Neiman. I have none. Commissioner Lindley?
No questions, thank you.
Commissioner Janetka?
Likewise. Thanks.
Ms. Smith, do we have anyone signed in to speak on this item?
Nope, no one on this one.
And Mr. McWhorter, what are your thoughts?
OPIC recommends approval for publication of 2 draft total maximum daily loads for indicator bacteria in Corpus Christi Bay Beaches, Cole Park, and Ropes Park as presented by the Executive Director.
Thank you. I agree with that. The draft TMDLs appear to meet all of the Clean Water Act requirements, and I think it's appropriate to put them out for comment. Commissioner Lindley, what are your thoughts?
I'm in agreement that we should approve.
All right. Commissioner Janeka, I'll entertain any additional thoughts or a motion.
Likewise, I'm in agreement. I'm looking forward on this one as we venture forward to see where the public's concerns and engagement are. I think it's an interesting policy problem. I'm looking forward to see our beaches appropriately guarded. But I'll make the motion that we approve the publication of and solicitation of public comment on 2 draft total maximum daily loads for indicator bacteria in Corpus Christi Beaches, Cole Park, and Ropes Park in the Nueces Rio Grande River Coastal Basin as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the consideration of the adoption of revisions to Texas Emissions Reduction Plan Guidelines for Emissions Reduction Incentive Grants and Texas Emissions Reduction Plan Guidelines for Seaport and Rail Yard Area Emissions Reduction Program. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Monte Gutierrez with the Air Grants Division. With me is Sierra Redding with the Environmental Law Division. This non-rule project revises the Texas Emissions Reduction Plan Guidelines for Emissions Reductions Incentive Grants, DARIP, RG 388, and Guidelines for Seaport and Rail Yard Areas Emission Reduction Program, SPRI, RG 524, to incorporate changes made to DARIP and SPRI rules in 30 TAC Chapter 114, Control of Air Pollution from Motor Vehicles, Subchapter K. The rules were amended to implement portions of House Bill 1346 and House Bill 1627 during the 86th Texas Legislature 2019 regular session. The proposed revisions to the DARIP and SPRI guidelines were published in the April 10th, 2020 issue of the Texas Register. A public hearing was held on April 28th, 2020. The public comment period closed on May 11th, 2020. The non-rule project team did receive public comments, and based on those comments, the rule team made non-substantive revisions. In conclusion, staff respectfully recommends adoption of the revisions to the DARIP and SPRI guidelines. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Gutierrez. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
None, thank you.
Ms. Smith, has anyone signed in?
No one is registered on this item.
And OPIC, what are your thoughts?
OPIC recommends approval of both adoption of both sets of these guidelines as laid out by the Executive Director.
Thank you. I agree. Adoption is necessary to bring these guidelines in line with the statutes and rules. So I think we should move forward. And colleagues, I'll entertain any additional thoughts or a motion.
I'll make a motion. I move that we adopt the revisions to the Texas Emissions Reduction Plan Guidelines regarding the Emissions Reduction Incentive Grants and the Seaport and Rail Yard Emissions Reduction Program as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
Items 5 through 28 are our enforcement docket, and the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division representing the Executive Director. Pending before you are items 5 through 28. The total assessed administrative penalties are $560,096, with $92,497 deferred, $88,262 applied towards supplemental environmental projects, and $379,337 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Thanks, none for me.
Ms. Smith, has anyone signed in to speak on these items?
On items 6, 7, and 8, we have individuals who have signed in but indicated that they don't wish to address the commission, and their presence will be noted for the record.
Thank you. And Mr. McWhorter, what are your thoughts?
My office reviewed these items, and we recommend approval of the proposed orders as presented by the Executive Director.
Thank you. I've reviewed these items as well and agree. I think we should approve them. And Commissioner Lindley, do you have any thoughts, anything to add?
No, I'm in agreement, thank you.
Commissioner Janeka?
No thoughts other than to make the motion that we adopt items 5 through 28 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
Items 29 and 30 will be taken up together. There are consideration of petitions for rulemaking submitted by the Texas Aggregate and Concrete Association and the Lake Houston Area Grassroots Flood Prevention Initiative, requesting the adoption of a new rule that would establish best management practices for commercial sand mining and other lawful purposes within the San Jacinto River watershed. The Texas Aggregate and Concrete Association and the Lake Houston Area Grassroots Flood Prevention Initiative should each present their respective petitions. The Texas Aggregate and Concrete Association may present first, followed by Lake Houston, although I understand that no one has signed in for Lake Houston currently. They will be followed by any interested persons. Again, currently no one is signed in. The Executive Director and the Office of Public Interest Counsel. OGC recommends limiting the parties to 5 minutes each for presenting their respective presentations.
Thank you, Ms. Smith. And I understand that Mr. Lefwich is here for the Texas Aggregates and Concrete Association. Mr. Lefwich, this is your opportunity to present your petition. If you'd like to do that, I'd ask you to please go ahead, sir.
All right, thank you. Thank you, commissioners, for your time today. I'd like to thank the TCEQ staff and Executive Director Toby Baker for answering questions during this process and clarification regarding TACA's petition for rulemaking. TACA has worked with the Lake Houston Grassroots Flood Prevention Initiative group over the last 6 months, pretty much, just to clarify and really make sure we are all in alignment and agreement on the proposed rules. I know there's still some work to do, and we look forward to working with that group in particularly and any other stakeholders that would like to join us also in this rulemaking process. Thank you again.
Thank you, Mr. Lefwich. I appreciate that. And let's just check one more time to see if there's anyone on the line to represent on item 30, the Lake Houston Area Grassroots Flood Prevention Initiative. Is there anyone to speak on behalf of that initiative? All right, hearing none and understanding that there are no interested persons signed in on this matter, let's turn to the Executive Director.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, my name is Rebecca Villalba with the Water Quality Division. With me today is David Galindo of the Water Quality Division and Michael Parr of the Environmental Law Division. Before you today, for your consideration, are 2 petitions for rulemaking requesting for the Commission to amend Title 30 of the Texas Administrative Code, Chapter 311, known as the Watershed Protection Rules. On June 15 of 2020, the Texas Aggregates and Concrete Association filed a petition for rulemaking, and on June 23, 2020, the Lake Houston Area Grassroots Flood Prevention Initiative filed a separate but similar petition for rulemaking. The 2 petitioners request for the Commission to adopt a new rule that would establish best management practices for commercial sand mining and other lawful purposes within the San Jacinto River watershed. The Executive Director recommends approval of the petitions to initiate rulemaking with stakeholder involvement. Through the stakeholder process, the Executive Director will further evaluate the technical aspects of the petitions to ensure adequate environmental protection is achieved. Thank you for your consideration. We are available to answer any questions you may have regarding the two rule petitions.
Thank you, Ms. Villalba. I have no questions. Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
Questions for me, thanks.
Thank you. Mr. McWhorter, what are your thoughts?
OPIC agrees with the ED's recommendation to initiate rulemaking and through the stakeholder process, consider the appropriate best management practices to include in any proposed rulemaking that may be developed.
Thank you. I agree. And I want to begin by thanking Mr. Leftwich and all of the petitioners for the work that they've put into this, working together to present these requests. These proposals appear to me to be a good idea, and I support opening the requested rulemaking process. I do want to caution, just to clarify on these petitions for rulemaking, that by approving the item, we're not approving any particular rule or rule language, but merely opening a rulemaking process without prejudging the outcome. So with that caveat, I support moving forward with this. And Commissioner Lindley, I'll collect any thoughts you may have.
No thoughts to add on to that. I'm in agreement that we should move forward with the rulemaking.
And Commissioner Janeka, what are your thoughts?
I think I'm in strong consensus with both of y'all. This definitely looks like a geographical area where industry and community stakeholders are in strong agreement that some best practices, some concerted efforts are necessary here. I'd be interested to see if there are implications for statewide best practices, but I think while we're looking at a close, critical area that was impacted by storms, it's certainly appropriate to take those lessons elsewhere. So I'll look forward to what ED comes up with and realize there's still quite a bit of work ahead. Thank you.
Thanks for your comments. I was nodding in agreement as you were laying out your thoughts, Commissioner Janeka. I'm ready to entertain a motion.
I will move that we direct the Executive Director to initiate rulemaking to examine the issues raised in the petitions for rulemaking submitted by the Texas Aggregates and Concrete Association and the Lake Houston Area Grassroots Flood Prevention Initiative concerning a new rule to establish best management practices for commercial sand mining and other lawful purposes within the San Jacinto River watershed, and that we adopt the Executive Director's proposed orders for docket numbers 2020-0821-PET and 2020-0836-PET.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, that returns us to item 1. Please call item 1.
Item 1 is the consideration of the proposal for decision and proposed order concerning the application by the Guadalupe Blanco River Authority for water use permit number 12378, seeking to divert and use not to exceed 75,000 acre-feet of water per year of the Guadalupe River Basin, the construction and use of one or more off-channel reservoirs, and an exempt interbasin transfer of water. The applicant and the protestant may each have 10 minutes of oral argument time, while the ED and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal, as the applicant bears the burden of proof in this matter.
Thank you, Ms. Smith. And I understand we have Ms. Cagle and Ms. Broadway signed in to speak on behalf of the applicant. And good morning to you both, and I'll ask you to go ahead when you're ready.
Good morning, Mr. Chairman, Commissioners Lindley and Janeka. This is Molly Cagle. Samia Broadway is with me. We're with the law firm of Baker Botts, and we represent GBRA in this matter. Kevin Patterson, who is the CEO of GBRA, Tom Bowl, our general counsel, Chairman Patella, executive team, Daryl Nichols, Jonathan Stinson, undoubtedly are all participating in the manner that one can participate in these proceedings. I am certain that you have before you, and Ms. Smith has provided you binders of briefs. We certainly have chopped down a few trees in this case. And rather than get into the minutiae, let me start with the big picture and leave it to my colleague, Samia, who actually was first chair in this case, to address the specifics. On the big picture, we have three questions. What's the problem? What does GBRI want? And what's the conflict? The problem is that a water supply project takes a minimum 12-year runway to get from the beginning of the runway to liftoff. And let me assure you that liftoff is simply that you have your permit and now you can start designing things and doing particular investigations. GBRI identified the need for a water supply 12 years ago. We had no customer yet. We had no money for intensive studies. We didn't know the exact location of the diversion. Heck, we didn't even know what technologies might be available. And that's true because the original application did not contemplate ASR. And now, and according to the testimony in the record, rather than starting with an off-channel reservoir, most likely we will start with ASR. But the key to the problem is flexibility. GBRI has got to have a permit that gives it flexibility to respond to the needs, to respond legally and efficiently to the needs of the public. And even if you think a 12-year runway is not what we're talking about in additional hearings, when GBRA and National Wildlife Federation concluded that we were going to be unable to reach a settlement, we then took 2 years from that date to today. So the process is not nimble. What do we want? We want the Commission to decide that the ALJs did not properly apply or interpret applicable law, rules, or written policy in the PSC. We want you to grant the permit that is Exhibit A to our reply brief. But what's the conflict? The conflict is that you have an arcane law. Water law has been around for a long time. You have years of interpretation. You have layers of new regulation and new legislation on top of it, and it's patchwork. Your executive director, with your oversight, has come up with process, interpretation, and applied policies that work. All of that under the watchful eye of the Texas legislature. What we need you to do is to follow those processes, and that will resolve the conflict. The conflict is, should you follow your executive director, or should you follow the process that NWF and the Texas Parks and Wildlife want you to follow, or the PSC? The standard here is what is not detrimental to the public welfare. And just to put a fine point on it, here the ALJs decided that there would be a negative effect on the public welfare if the permit is not issued.
That's the big picture. I'm happy to delve into the details, but briefly, the three issues that the PSC got wrong are that an off-channel reservoir did not trigger notice under 11.124. Second, TCQ authorizes diversion reaches, and that is proper. Third, in SB3 basins, section 11.152 of the Water Code no longer applies. We'll reserve our time for rebuttal.
Thank
That's
you,
4 minutes.
Thank you, Ms. Broadway. And I know you're rushed for time. I was taking notes as quickly as I can. Could you tick through those issues one more time for me?
Happily. The first issue is an off-channel reservoir does not trigger notice under section 11.124F, and that's because it's not an appropriation. The second is diversion reaches. Contrary to the ALJ's position, TCQ authorizes diversion reaches by examining the most upstream and downstream points, thereby saying that any diversion point in that reach has satisfied the applicable requirements. And the third is that the ALJs thought that the Commission had an independent obligation to conduct habitat assessments and evaluate mitigation under section 11.152, notwithstanding SB3, Senate Bill 3, which is applicable in this basin.
Okay, I appreciate that. And in fairness, I don't think we should count that time against your rebuttal, but we'll give give Mr. Hess the same consideration. I don't have any other questions for the applicant at this moment. Commissioner Lindley, any questions or comments at this time?
No, thank you both.
And Commissioner Janeka?
Likewise, thank you.
Great. Mr. Hess, I understand you're here for the protestants and will be making that presentation.
Yes, good morning. This is Myron Hess. I'm here on behalf of the National Wildlife Federation. Can you hear me?
I can. Good morning, Mr. Hess. It's good to hear your voice, and please go ahead when you're ready.
Thank you. Throughout this proceeding, the National Wildlife Federation has proposed reasonable approaches for addressing deficiencies in the application and proposed permit resulting from the lack of a project design while still complying with applicable requirements. And that's the crux of the issues before you this morning. I will focus my comments initially on compliance with the section 11.152 of the Water Code, but as time permits, I will also touch on a few additional issues. There's really no reasonable basis to dispute that Water Code section 11.152 applies to GBRA's application, as the proposal for decision recognizes. That statute mandates an assessment of effects from issuance of the permit on fish and wildlife habitat that is separate from consideration of flow impacts addressed by environmental flow conditions. The legislature was quite explicit in acknowledging the eminently logical conclusion that flow standards address environmental flow conditions and not other environmental issues such as impacts on habitat when facilities are constructed, destroying that habitat, which is not in the river and is not protected by flow protections. The Commission's rules and the proposal for decision acknowledge that distinction. However, the proposal for decision departs from the plain language of the statute in recommending that the off-channel reservoirs authorized in the permit should be excluded from being considered part of the project to store, take, or divert in excess of 5,000 acre-feet per year under section 11.152. The permit application seeks, and the proposed permit expressly includes, off-channel reservoir authorization as an essential component of the project. GBRA's argument seeking to rewrite the reference in section 11.152 to store, take, or divert, as though it said to appropriate, ignores the language the legislature used the legislature explicitly made the distinction between those terms in separately referencing both of those in section 11.147E1. That argument also ignores section 297.53G of the Commission's rules, which limits how certain amendment applications that do not involve a new appropriation are to be reviewed under section 11.152. That rule provision would be meaningless, would serve no purpose if section 11.152 did not otherwise apply to those non-appropriation applications. If they're not subject to it, there's no need for a rule describing how they should be assessed under that statute. Section 11.152 uses the term project interchangeably with the impacts of issuance of the permit. The PFD, although not identifying any ambiguity in the statutory language, construes the implementing rule as supporting a reading of the statute that's inconsistent with the statute's plain language. Specifically, the PFD relies on section 297.53C of the rules, which states, an assessment shall include the project site as well as potentially impacted habitat upstream, adjoining, and downstream of the project site, and construes that language as supporting the limitation of the required assessment solely to areas adjacent to a stream. The analysis in the PFD takes that rule language, which directs an expansive review of impacts to include the project site plus impacted habitat extending beyond the project site, and turns it on its head by construing it as supporting a review of something less than the project site. The site of this project unquestionably includes habitat adjacent to the Guadalupe River, where undefined diversion facilities will be constructed, and habitat at the currently unidentified locations where one or more off-channel reservoirs will be constructed. There is no basis in the statute, the rule, or in commission precedent to conclude that the location of off-channel reservoirs expressly being authorized somehow is not part of the project site required to be assessed. Prior amendment applications seeking authorization for off-channel reservoirs are not relevant precedent for Section 11152 because, unlike this application, they're controlled by the amendment provision, Section 11.122B of the Water Code, and Section 297.53G of the rules, which I discussed previously. Those provisions limit how Section 11152 applies for standalone amendments that don't involve any kind of new appropriation that's subject to 11.152. The only relevant precedent identified is Permit 5731, issued to LCRA in 2011. That permit does include negotiated language, particularly regarding flow protections. However, the Commission voted to issue the permit, which explicitly acknowledges the applicability of Section 11152 to off-channel reservoir sites, and the right to notice and an opportunity to request a hearing on issues deferred as a result of you authorizing a two-step process like GBRA seeks to use here. Permit 5851, which was issued to the Brazos River Authority, is not relevant precedent because that permit did not involve or authorize any new works, so it did not raise any issues beyond flow impacts, and again, flow impacts are addressed by the environmental flow standards, so that permit didn't address those non-flow impacts. Just quickly, with respect to notice, the proposal for decision appropriately acknowledges the failure of the application to comply with explicit requirements of Water Code Section 11124F to provide mailed notice to local government officials regarding proposed storage reservoirs. The Commission's rules are unambiguous in recognizing the obvious reality that off-channel reservoirs are storage reservoirs. Again, NWS proposed an accommodation to say, we let this application move forward, but you have to achieve compliance with those statutory and regulatory requirements down the line, and that can be done through an amendment process. But that amendment process has to provide notice to allow people to raise issues related to those sites when they are designated. The same issues that could have been raised if those sites had been designated in the initial application. So we proposed a way to accommodate GBRA's approach, but it has to comply with the statute and the regulations. With respect to specification of the location of off-channel reservoirs and notice. Section 295.7 of the Commission's rules expressly requires that the locations of off-channel reservoirs must be specified in the application. I want to just note quickly, although there are not specific requirements for the Commission to include a quantified return flow requirement, including such a requirement would help to meet environmental flow needs. The Commission, in adopting the flow standards, acknowledged that it had not evaluated are determined that the flow standards that adopted were adequate to protect a sound ecological environment into the future as water rights are fully exercised. So there are two mechanisms to try to address that we have proposed. One is a quantified return flow requirement. The second is to make sure that the reopener provision.
Yes, next up is the Executive Director staff. Good morning, and go ahead when you're ready, please.
Thank you, Mr. Chairman, Commissioners, Public Interest Council. I am Robin Smith with the Environmental Law Division, and with me is Dr. Kathy Alexander with the Water Availability Division. The administrative law judges in this case recommended that GBR be required to file an amendment to provide the location of any OCRs with an opportunity for a contested case hearing. They also recommended that in that amendment, that the GBR give notice of the diversion structures and perform a habitat assessment. We respectfully disagree. OCRs, by definition, are not on a state water course. Section 11.124, which requires notice for reservoir, begins with the requirements that an application to appropriate unappropriated state water. We believe that the rest of that section goes back to that application to appropriate unappropriated state water. We do not believe that these statutes mandate that an OCR be included in the application and that there be separate notice for location of the OCRs. The new appropriation of state water in this application is from the Guadalupe River, not at the OCR. The OCR stores water that is appropriated at the diversion points in the river that have been piped to the OCR. So the diversion and intake structures are a diversion for new appropriation of state water. So additionally, the location of the diversion points have already been provided in the application. It is a diversion reach. Diversion reaches have been used in TCEQ permits for years, and the Commission in BRA SysOp's case found that that application sufficiently identifies diversion points and reaches and complies with rules. The ALJs also found that the TCEQ's interpretation of Section 11.152, that it does not apply to impacts beyond the environment on the stream, is reasonable and in harmony with the statute. Now, the ED agrees. They then say, however, that to the extent not addressed by environmental flow conditions, the impact on fish and wildlife habitats of granting the application from projects located on a water course should be assessed pursuant to Water Code Sections 11.147 and 11.152, and that this assessment will occur once the actual locations for the diversion structures have been identified. We think this is correct for some of the reasons we mentioned above, but also because the impacts on fish and wildlife have been addressed in the environmental flows for the Guadalupe River Basin. It is outlined in the adoption of the environmental flows for the Guadalupe River Basin in the Texas Register. The TCEQ considered fish and wildlife habitat in the Guadalupe River and determined that the adopted standards would maintain habitat conditions in the Guadalupe River after diversions of water. In addition, the GBRA has agreed in the negotiated draft permit to include a provision that requires GBR to take reasonable measures to avoid impingement and entrainment, including but not limited to installing screens on any new diversion structures within the reach. So therefore, the ED requests that the Commission grant the TCEQ's exceptions to the PFD and issue the negotiated draft permit. Thank you. We are available for questions.
Thank you, Ms. Smith. I have none. Commissioner Lindley, any thoughts, questions?
No, no questions. Thank you.
Commissioner Ginecka?
None for me, thanks.
Thank you. And we'll hear next from our Office of Public Interest Counsel.
Good morning, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez, for the record, and I represented OPIC in this matter. Can you hear me okay?
I hear you loud and clear. Thank you, Mr. Martinez.
Great, thank you. OPIC agrees with the National Wildlife Federation. Additional provisions should be added to the permit to provide protection of freshwater flows. Texas Water Code Section 11.147E1 mandates the inclusion in any permit authorizing and water of a provision allowing for adjustment, if determined to be appropriate, by the Commission of the conditions included in the permit to provide for protection of in-stream flows or freshwater inflow. This reopener provision allows an increase limited to 12.5% of the requirement contained in the permit when it was issued of environmental flow protection if the Commission subsequently determines that the flow standards at the time of permit issuance were insufficient to protect a sound ecological environment. However, the language in the proposed permit does not contain any quantifiable total as a starting point for adjustment of freshwater inflows. The negotiated draft permit as currently written fails to effectively implement the intent of Water Code Section 11.147E1 to ensure meaningful potential to adjust to permit conditions to increase protections for freshwater inflows under appropriate circumstances. OPIC's position is that without incorporating permit language that can serve the function of an annualized total for freshwater inflows, the potential for adjustment to protect freshwater inflows does not exist. The second point where OPIC disagrees with the proposal for decision concerns the assessment of impacts to fish and wildlife habitat. Sections 11.147E and 11.152 of the Water Code mandate that for an application for a permit to store, take, or divert water in excess of 5,000 acre-feet per year, TCEQ shall assess the effects of the issuance of the permit on fish and wildlife habitats and shall include conditions necessary to maintain fish and wildlife habitats. GBRA's application authorizes construction of one or more off-channel reservoirs. However, the PFD construes provisions as only applying to impacts on the water course in deference to the ED's interpretation. OPIC's position is the required assessment of the project being authorized should be undertaken comprehensively to include not only the water course, but also the project site and all potentially impacted habitat, and the assessment must be conducted in compliance with all applicable requirements, including opportunities for public participation. Based on these concerns, OPIC recommends the changes to the permit discussed in our briefs on file in this matter. And thank you. We are available for any questions.
Thank you, Mr. Martinez. I have none. Commissioner Lindley?
No questions. Thank you.
Commissioner Ginecka?
None, thanks.
Thank you. And I think that takes us back to the applicant for their rebuttal.
Thank you, Chairman, Commissioners, Executive Director, General Counsel, Public Interest Counsel. My name is Samia Broadway for applicant GBRA. The Executive Director and staff got this right. Ms. Smith's presentation is exactly correct. NWF asserts that it proposed reasonable approaches to issuing GBRA a water right, but it's not NWF approaches that are issued here today. The question before you is whether 11152 and Senate Bill 3 are the applicable requirements post Senate Bill 3 rulemaking. Do you apply 11152 or do you apply Senate Bill 3? Your staff says no, we say no, and you, the Commission, have also said no on 3 separate occasions, in 2 rulemakings and in 1 new water right. You have found repeatedly that since the adoption of 11147E3, which states that notwithstanding the previous requirements in sections B through E, you will apply in any new water rights those provisions necessary to protect the environmental flow standards in place of 11152. You have been asked repeatedly to do something different, and you have said no every time. We ask you to do so again today. In 2011, in the rulemaking, Texas Parks and Wildlife pointed out exactly what NWF is pointing out today, that there appears to be some tension in the statutory mandate between 11152 and 11147E3. That is true, there is tension, but you have resolved that tension. And you've said in that rulemaking that sections 11147, B through E, or how the Commission protected the environment prior to Senate Bill 3. Similarly, in issuing the order to BRA, Permit 5851, the System Operations Permit, you stated in a finding in that order that a separate analysis under Texas Water Code 11152 is no longer required with the adoption of the Senate Bill 3 environmental flow standards. But that was not the only time you made this finding. In 2016, when expressly asked by NWF to make the same finding it asked for today, you rejected that provision, and you said that the Commission's objective or goal is to protect the adopted environmental flow standards along with the interests of senior water rights holders. That has been your consistent and reasonable interpretation. The Executive Director staff has implemented it throughout this basin and in this draft permit, and we ask that you do so today. Moving on to another area that NWF focused on, Permit 5731, which was the LCRA permit. It did contain negotiated language, but I want to be very clear. GBRA does not seek and does not want any kind of two-step bifurcated process that was offered by National Wildlife Federation. That is not TCEQ's rules. It is not required by statute. LCRA's permit was the product of a negotiated settlement, and this Commission and the Executive Director have been very willing to consider parties coming before you with negotiated and agreed to provisions. So long as they do not clearly violate your rules or statute, you've been willing to entertain them. And GBRA has, in fact, asked for such accommodations in this context. We appreciate that kind of accommodation as the parties work out the differences between themselves. But that does not create any kind of binding precedent for GBRA in looking back at a pre-SB3 water right issued to LCRA in the context of that kind of negotiated settlement. Finally, I'd like to touch upon 11124 notice for the off-channel reservoir. Ms. Smith described this very well, and so I won't spend a lot of time here. But the off-channel reservoir is not an appropriation of state water, and as a consequence, it does not trigger any kind of notice under Section 11124 independently of the appropriation, which is the diversion of water from the Guadalupe River. The idea that an off-channel reservoir would trigger an entire amendment and hearing on issues that are beyond what the Commission considers applicable in a post-SB3 basin is simply beyond where TCEQ's rules, practices, and where the statutes require for new issuance of a new water right. While it is true that the off-channel reservoir in LCRA's 5731 permit receives this kind of bifurcated amendment, notice, and evaluation, that is indicative in some ways of the difference between the problems that Molly Cagle articulated at the beginning of the proceeding. GBRA has a need for water supply for a rapidly growing region of the state. And this water supply will serve that public welfare need in a way that is environmentally protective and a way that complies with TCEQ's rules, practices, policies, and statutes. The water right that GBRA requests contains every required provision of TCEQ law and rule. It satisfies the environmental flow standards, and it satisfies procedural and substantive requirements of this agency. There are no deficiencies. We respectfully ask that you, the Commission, continue to apply your interpretation of the statutes you are authorized to implement, and that you issue GBRA Permit 12378 as provided by GBRA and the replies of sections dated 2020, and we're available to answer any questions you may have.
Thank you, Ms. Broadway. I have none. Commissioner Lindley, any questions for Ms. Broadway or any of the parties?
No, thank you all.
Commissioner Janeka.
Thank you. No questions at this time.
Okay, well, colleagues, I am going to need a few minutes to digest what we've just heard and to organize my thoughts. I'm going to propose that we take a short recess. I'm also preparing a document that I'll share when we return from the break that'll help guide us, I hope, through the discussion. So I'm going to propose that we take a 5-minute recess. The time now is 10:25, so I'm going to suggest that we reconvene at 10:30. All right, I see nods of approval. The time is 10:25. We stand in recess. Well, colleagues, those 5 minutes went quickly. I think maybe 6 minutes. The time is 10:31. We're back from a short recess, and I'm going to recommend that we grant this application and issue the permit. But my analysis differs from the ALJ's in a few instances. So I'm also going to suggest several changes to the ALJ's proposed order. And I've gathered those changes in a document that I've titled Proposed Order Changes for Item 1, which I think we're going to make available as a download. I'm not yet seeing it available as a download, but let me see if I can figure out how to work my webinar to identify that document, because I want you to have that handy as we talk through the issues. All right, I saw it up on the screen.
Chairman, while we're waiting for that, I will go ahead and just make a quick comment as well. I'm with you already. I'll be interested to see what proposed changes you have, but I'm in agreement that I'm going to be voting that we move forward with granting the permit, and that we, issue the proposed order with some changes. And the changes, I know we'll get into discussion on, and we'll see how similar we are. But I found some changes that need to be made to the findings of facts, including maybe a deletion or two. I think there's some conclusions of laws that are obviously going to have to be modified, and I think I'm going to propose amending provisions, or amend ordering provisions on number 1, some changes there. So.
Yeah, thank you for that, Commissioner Lindley. I think, we may find that our ideas overlap here, and I noticed that the document is available, at least on my screen. It's identified under the handouts as Item 1 PDF. So let me give you each a moment to pull that up and make sure you have the whole document in front of you.
I can see it on my screen. I'm not sure if there's, I guess we'll all review it together on this one shared screen then.
Yeah, we can do that. I think for the benefit of anybody who's logged in on the GoToWebinar screen, there's a control panel, and one of the sections of the control panel identifies handouts, and the second one on my screen is identified as Item 1 PDF, and that document is the proposed order changes for Item 1 that I'm talking about. And so the document should be up on your screen, but in addition, you can download it and have a copy handy. So again, my thought is to have this document ultimately form the basis of a motion, and it's really a discussion draft subject to further revision depending on how our conversation goes. I am very interested to hear your thoughts. So let me suggest that we take each of the contested issues in the order that they're presented in the PFD, and we can talk through our respective analyses. And just to provide a roadmap of where we're going, let me tick through the issues. And I would take them in this order. First, environmental flows and freshwater inflows. Second, return of surplus water. 3, the issue about fish and wildlife review for off-channel reservoirs and diversion structures. 4, location specificity regarding diversion points and off-channel reservoirs. 5, notice to the county. 6, public welfare review. 7, waste and conservation review. 8, project timeline. 9, consistency with the coastal management program. And 10, transcript costs. And as we work through these issues, then I'll cross-reference to my draft document. So that sound like a plan?
Sounds like a plan.
All right. Well, let's dive into it. On issue 1, I agree with the ALJs that the negotiated draft permit is adequately protective both of the environmental flows in the river system and the freshwater inflows to the bays and estuaries. The e-flow rules are properly implemented in special conditions 6A through 6H, and the water availability modeling demonstrates that freshwater inflows are protected consistent with our rules. So I would not propose any changes to the ALJ's proposed order with respect to issue number 1. And Commissioner Lynn, let me check in with you first to see how you came out on that issue.
I came out in complete agreement on that one.
And Commissioner Janeka?
Likewise.
Okay, let's move to issue 2. I agree with the ALJs that the National Wildlife Federation's proposed 50% surplus return flow provision is inappropriate because it is not necessary as contemplated under Texas Water Code 11.046B, is not necessary, that's a word from the statute, for the protection of San Antonio Bay. So again, I would propose no changes to the order on this issue. And Commissioner Lindley, let's start with you to see where you came out on that one.
I'm in agreement. The only thing I would add to what you stated is that the Commission has previously, rejected similar requests to require inflows over the amounts necessary to protect the environment in the Senate Bill 3 rulemakings. So with that, I'm in agreement with everything you said.
Thank you. Commissioner Janeka?
Likewise, I think the ALJ's analysis on PFD issue 2 is consistent with Commission precedent there. I'm comfortable with that as proposed.
All right, appreciate that. So again, no changes to the order on issue 2, which takes us to issue 3. And I think that the scope of review for fish and wildlife considerations under Texas Water Code 11.147 and 11.152 really is subject to debate, and that reasonable minds can differ on this. But with respect to whether the review extends to off-channel reservoirs, I think the better reading is the one that's been adopted by the executive director and adopted by the ALJs, specifically that the scope is limited to impacts on the water course. And so the next question for me would be the extent to which the environmental flow rules supersede or satisfy the fish and wildlife review under sections 11.147 and 11.152. The executive director's position is that compliance with the environmental flow rules fully satisfies the required fish and wildlife review. The ALJs, however, adopt the NWF position that there is a residual obligation for review with respect to the impacts of diversion structures within the watercourse that are unrelated to flow, and principally talking about impingement and entrainment. And the ALJ's proposed order contemplates addressing that residual obligation for review as part of a future permit amendment. And it's my view that a future amendment is not necessary. So assuming, just for the sake of argument, that there were some residual obligation to review impacts at the diversion structures, I think that obligation has been satisfied. The executive director's 2013 environmental analysis addresses both environmental flows and impingement at the diversion structure. And the original permit, as well as the negotiated draft permit, include requirements addressing impingement, and I'm referring to special condition 6L. So whether or not there is some residual obligation for review, I think that the the review has been satisfied. In addition, I would accept GBRA's offer to bolster the requirement at Special Condition 6L, as it does provide some additional comfort, and that's both with greater specificity about the measures to be undertaken, but also the addition of an alteration procedure to help ensure enforceability. So again, in my view, the Fish and Wildlife Review is satisfied in any event without deciding whether there's a residual review obligation following our adoption of the EFLO rules. So let me pause there and see if that made any sense, and see how y'all came out. Commissioner Lindley, let's begin with you.
I was jotting down notes, but yes, it makes sense to me, and I agree with everything you said. I don't think I'm even going to try and pile on, because I think while it's a confusing topic and it's there's a lot of things for debate in there, I don't think I'm going to try and pile on and make it more confusing, and just leave it at, I agree with you that the Fish and Wildlife Review is satisfied, and that assessments don't apply to storage in off-channel reservoirs in this situation. And the only thing I will add, just for anyone listening in, is one thing that also got me more comfortable with this was something in the record, and that was the settlement with Texas Parks. There were things in there that provided me a lot of relief, because there were extensive commitments made in that settlement as well that go towards protectiveness of fish and wildlife. And so that also made me comfortable with this decision, and I will stop there because I'm in agreement.
Thank you, Commissioner Lindley. Commissioner Ginecco, what are your thoughts?
I was, I have to confess, I jumped straight to your shared note sheet that you had here. This, I think, suggested some changes that fits in with your observations here on this matter, and I'm in agreement across the board. And I want to thank Commissioner Lindley for making that point about the record. I think the involvement of Texas Parks and Wildlife in this permit, going back to the beginning of the issuance through where we are today, is very important to note, and certainly does give a lot of practical reassurance in my mind that the practical needs are being met, where the law as it stands and our agency's interpretation of that, I think, is certainly appropriate, and leading up to this matter, I'm comfortable with everything you've suggested, Chairman.
Great, thank you, Commissioner Ginecco. All right, so that's the analysis piece. Now, how to conform that.
Can I ask one quick question to go along with that discussion? Can we scroll down so we can finish seeing the end of 94.C, and probably maybe even further down to see kind of the language you used for amending of Fact 113, since that's all kind of in this. Oh, maybe go back up just a smidge. Sorry.
Yeah. Let me suggest this. Why don't we take a moment and see if you can find, each of you can find those handouts and download them so that they're convenient to you, so you can flip through them and not have to follow what's on the screen.
Yeah.
And then what I'm going to do is, now that we're in agreement on the analysis, I want to, step through carefully the changes that I'm proposing, and finally get to this proposed change document and connect all the dots for you. But see if you can find those handouts and download them and pull that up.
Walkthrough is absolutely perfect for me, Mr. Chairman. You pulled me out of the muck there, Commissioner Lindley, on the right-hand bar for the webinar, where you control the microphone, and one of those tabs, the drop-down, is for handouts, and you can see there's two now. One's typically the agenda, the other is item 1.pdf. That's where Chairman brought my attention to it. It saved me, and having the document to be able to technology these days. This is great. I want to just.
Yeah, I'm having a hard time
to come in.
Documents, but I don't have control over it still. I don't know what this is a user error issue, for the record. Yeah, I mean, I can see the document when I click on it, but I don't have, what am I doing wrong?
So can you actually see the PDF icon and the name of the document, item 1 PDF? And if you hover over it, are you able to click on it?
Well, no. What am I doing wrong here?
It worked for me, but in a browser that was hidden, so I had to dig a little bit when you click the link.
How about a workaround? We could see if our general counsel could email you, or the clerk could email you a copy of the document.
That's probably faster for me. I'm scared I'm going to break GoToWebinar because I've had my issues with it.
Well, I feel your pain. I was on a Teams meeting yesterday, and my computer had neither a camera nor a microphone. I discovered about 15 minutes into the meeting that I could use the chat function, which was helpful. But
technology is a blessing and a curse.
it is both. We'll just pause for a moment to give you a chance to get that in your email.
I've got it. We're good.
All right. Okay, so let me step through the specific changes that I'm proposing, consistent with the analysis that we've just discussed and laid out. The first one is to replace finding of fact number 94 with new findings of fact 94A through 94C, and that is on set lines 3 through 36 on page 1 and spilling onto page 2 of the document. And then let me pause there, give you a chance to digest that, and then we can move on to the next suggested change, which is to conclusions of law.
I'm good. I'm in agreement. Maybe that's a better way to say it.
Commissioner Janeka?
Likewise, I'm supportive of this language, this proposed change.
Okay. The next change to conform the order to my analysis begins at line 108, and that is the addition of new conclusions of law 28A and 28B, and I'll give you a chance to review those as well. That's on page 3.
Will you walk through, maybe you're about to, so if I'm jumping ahead, I don't mean to. When you talk about maintaining the ALJ's proposed language for Section 5, if I'm jumped ahead.
Yeah, I haven't quite gotten to that yet.
Okay.
We're just on conclusions of law, the new conclusions of law 28A and 28B.
Yeah. I'm good with those.
Okay. We'll give our commissioner.
Likewise.
Okay.
Yeah. Thank you.
So the next change that I would suggest to conform the order to the analysis is the addition that was proposed. This is the idea proposed by GBRA, adding some additional structure and specificity to special condition 6L, and that's on page 4, beginning at line 131. An amendment to ordering provision number 1.
So just to restate I think I've reviewed it and I think I'm in agreement, but to restate in plain language for the benefit of the viewers at home, this will go back to the GBRA proposed alternative of additionally submitting to our agency what they've already submit or would be submitting to the U.S. Army Corps of Engineers for any diversions or off-channel reservoirs, rather than the proposed Special Condition 6L, which sets a specific 10-year deadline and then prior to any diversions, as proposed by the ALJs.
Right, and just to telegraph where I'm going, I'm not finding any deficiency in what's been presented that would require a future amendment process. So,
I agree.
With respect to this issue, part of the answer is that GBRA will provide more specific information. Once those structures are identified and provide information that's really consistent with, redundant to the U.S. Army Corps of Engineers 404 review. Does that make sense to y'all?
I think I'm comfortable with that.
I think so. 1 minute. I'm reading through some of my notes here. I'm definitely good with the language you have for amending ordering provision number 1 regarding the Special Condition 6L as follows, and then that paragraph. That I am good with all that.
And I haven't gotten to back to your question yet. I promise to eventually, though, regarding section 5. I promise I will get back to that, but it wasn't part of the edits that I contemplated in connection with issue 3.
Okay. Yeah, I think I'm good.
Okay. And there is one other change to the order that I would make in connection with this issue 3, and that's as recommended in the ALJ's reply to exceptions. It's conclusion of law 27, and that change is referenced at lines 104 through 106 on page 3. And it's simply to replace the word "in" with the word "on" in reference to the water course.
I'm in agreement on that.
I'm good with that change.
I'm sorry, Commissioner Jackson, did you say you're good with it?
Sorry, I am good with that clarification.
Okay. I thought you might have said I'm getting to it. So, okay. I think that works through the analysis and then just sort of the logistics of the edits for issue 3. So I think we're done with issue 3. Let me move on to the 4th issue, which relates to the specificity of locations. I agree with the ALJ's conclusion that the Commission's rules require some information about the location of diversion points and off-channel reservoirs, but the level of specificity, in my mind, is really a practical question about what is required to complete the necessary technical review. And the location really does not have to be exact so long as the commission has sufficient information to demonstrate that the proposed diversion meets all of the requirements to issue the permit and protect senior water right holders in the basin. And that understanding is consistent with the reasoning in past commission decisions that have determined that the level of specificity required is directory and not mandatory. And I'll reference the Brazos River Authority Systems Operation Permit Order, which is part of the record before us. So here in this case, GBRA identifies the locations of diversion points and off-channel reservoirs, not with exact precision, but with sufficient specificity. With the location information that was provided, the diversion reaches, et cetera, GBRA's evidence and the executive director's modeling were able to demonstrate that there's a sufficient flow to approve the full water allocation for this project. So in my view, this is not a deficiency. We do not need to come back in some future amendment process and cure a deficiency, because there is none in my analysis. Let me pause there and get your reaction to my analysis. If you all agree, then we can get into the logistics of how to accomplish that in the order. So Commissioner Lindley, maybe we can begin with you.
I'm in agreement. I'll just leave it at that. I don't have anything to add on. I think you stated it well, so I'm in agreement.
Okay. Commissioner Janeka, what are your thoughts?
Likewise, I had some concerns about the orders proposed on this point. I think your analysis absolutely comports with mine in terms of the level of detail was provided in the reach versus the point is an interesting policy problem. I think our ED will have to work through, but I think we've addressed it and answered it in this case. I think your proposal addresses the concerns here.
Okay, I appreciate that. Getting into the logistics of how to conform the order to that analysis. Let's begin on page 2 of my draft order at line 38. And what I'm proposing is that we amend finding of fact 113 and add 2 new additional findings, 113 and 113A and 113B. And those, let me pause there and give you the time that you need to digest that, and then we can move on to the conclusions of law. So again, we're at line 38 through 55.
I am in agreement with those changes.
Likewise, support those changes from here. Thank you.
Okay, so moving forward to the conclusions of law, I would replace conclusion of law 7 with 3 new conclusions of law, 7A, 7B, and 7C. And that language is set out beginning at the bottom of page 2, but mostly the top of page 3. And I'm referring to lines 77 through 94.
I'm good with those proposed changes.
Likewise.
And that takes us back again to ordering provision number 1, and I would amend that to, and I'm looking at line 129, I would amend that ordering provision to delete the ALJ's changes at special condition 6I.
I think that deletion is appropriate.
Yeah, I would agree.
All right, I appreciate that. That takes us through all of the edits that I would have on issue 4, and so that brings us to issue 5. So my analysis on issue 5 is as follows. I agree with the administrative law judges that the plain language of Texas Water Code, section 11-124F, pre-application notice requirements does apply both to both on and off-channel reservoirs. And there's no question that although GBRA met its notice requirements for its application under Texas Water Code section 11-132, it failed to provide this pre-application notice to Gonzales County. And since GBRA can't turn back the clock, there's no real cure for this failure. And to have a notice as part of a future permit amendment, for example, that can't cure a failure to provide a pre-application notice. And I do appreciate Mr. Hess pointing out that this is really an accommodation. I don't mean to suggest that he would take the position that this is a cure, but in my mind, it is first very much a deficiency, and second, not one that's amenable to a cure, since we can't turn back the clock. I think, though, that there's a distinction to be made between this pre-application notice and an APA type notice that GBRA did meet with its filing of the application. Importantly, this pre-application notice is not a condition precedent to establishing the Commission's subject matter jurisdiction to issue a water use permit. And that view is supported by Texas case law, including the City of DeSoto versus White, which is a 2009 decision from the Texas Supreme Court. I'd also point out that there's sort of a pragmatic considerations here. Among other problems, the conclusion that this particular defect is jurisdictional, if we were to make that conclusion, the consequences would be unreasonably severe. So it's my view that the Commission can grant this authorization despite the pre-application notice defect, and it bothers me some that that position could be understood as providing no consequences for a failure to provide pre-application notice. But the consequences of taking the alternative view that this is really jurisdictional are, in my view, wholly unreasonable. So that's my analysis. And let me pause there and just see if we're on board or where we might differ with respect to the analysis, and then we can get into the logistics of the order. Commissioner Lindley.
Well, I will state I'm in agreement. This issue was hard for me. I mean, even as recent, I think it was our last agenda together, I commented that, local notice or notice to local governments is very important to me. And so keeping that in mind, when this issue came up, I struggled with this one. But I want to say I am in agreement. I do think that the county-only notification is not part of the APA, like you stated. And so I agree, and I would recommend that we not include the ALJ's amended special condition 6I requiring county notification compliance via future amendment application. This one was very difficult, I will say that.
Appreciate that. Commissioner Janeka?
I share much of Commissioner Lindley's heartburn on this issue. I agree with you, Chairman. Ultimately, I think this is a thorny issue in terms of the practicalities, implications of it, but ultimately I agree with you that this is, it seems severe to interpret that requirement as jurisdictional. I'm not sure that I see a different or more, there's no practical remedy there. So I'm in agreement that the appropriate way to move forward at this point would be as you're proposing or working up to recommend.
All right, appreciate that. Let's kind of turn to the how we accomplish this through edits to the proposed order. And I would begin on page 2 of my document, change document, at line 57. And I'm proposing deleting conclusion of law number 6 and replacing it with 3 new conclusions of law, 6A through 6C. So let me pause there and give you a chance to work through that and see if we're in agreement on the language. So take all the time you need.
I'm in agreement on that deletion and addition with the language there.
Likewise, I'm comfortable with those 3 draft conclusion of law statements.
Okay, I think the next changes we have to make are the ones that you referenced. The one that you referenced, Commissioner Lindley, to ordering provision number 1 to delete the ALJ's changes. I think this is our second deletion, actually, of this provision at Special Condition 6I at line 129 on the last page. I'll give you a chance to flip to that, make sure we're okay.
I agree. It should be doubly deleted.
I would agree.
Okay, and because in my analysis, there's no need for a future amendment to this permit on this issue or any other, I'm also going to suggest that we amend conclusion of law 29 as that's described on page 3, line beginning at line 122. So it's lines 122 through 124.
I'm good with that deletion.
So,
Commissioner Janeka, there was kind of this introductory clause to conclusion of law 29 that's inconsistent with
okay,
with the idea that there will be no amendment in the future. So I'm just suggesting that we strike that.
Good catch. I'm in agreement there.
Okay. All right. That actually winds up issue 5. On issue 6, I have no reason to question the ALJ's findings that the proposed appropriation will not be detrimental to the public welfare, so I'm not proposing any changes with respect to issue 6.
I agree.
I'm in agreement.
Okay. That brings us to issue 7. I agree with the ALJ's determination that GBRA has satisfied the requirements for promoting conservation and avoiding waste. I also agree with the National Wildlife Federation's position that it's more appropriate to articulate Section 5 of the negotiated draft permit with an "and" as the ALJ's order, as the ALJ had originally recommended. that word "and" is also consistent with the language in 30 TAC section 297.158. And in my view, it's appropriately protective without being expansive. So let me pause there. That's really it for my analysis. And if you all agree, we can get into the edits in a moment. But Commissioner Lindley, how did you come out on issue 7?
I came out, I guess, just a little different. You know, I think the ALJ has made an appropriate conclusion in their original PFD discussion that the NDP's language for what's required in GBRA's water conservation plan should more closely track the defined term established in our rules. You know, I thought the ALJ's original proposed water conservation plan language has the most legal support, and so I was going to propose that the commission use the ALJ's original recommended section 5 conservation provision, change using "and" in the first sentence. So I was going to say we should amend conclusion of law number 22, which I guess is what we're both kind of getting at. So that's kind of where I came down. I don't know. I'll stop there for a minute.
I'm flipping to, okay, so you're suggesting changing conclusion of law 22 to do what exactly?
Oh, let me get to where my actual changes are. So we should do. Well, gosh, now I have way too many papers in front of me.
I'm struggling with the same thing.
We may have 3 different directions of thought here. I think I'm in agreement with both of you. I think you're describing the same problem from different directions, and
oh, okay.
We all may be landing on the same clarification there.
I had the same hunch.
Yeah, maybe I might have laid it out wrong then, but I did find what I would change the language to. So let me, here's yours. Let me see if, I think we probably are in agreement. I'm sorry for the confusion there.
I have an idea, Commissioner Lindley. How about if you and I give Commissioner Janeka an opportunity to straighten us out?
Yeah, that's
on the spot, Commissioner Janeka. Bring some clarity to this.
Fix this mess I created.
No, yeah. Again, restating in plain language so all the people like me can understand at home. It sounds like we're all in agreement that the one change of a single word did add some potential confusion, and so we're all in agreement that an original recommendation, a language originally recommended by the ALJs on the proposed water conservation plans were desirable there, and looks like we've all flagged conclusion of law 22 as ripe for clarification in that regard. I think that describes changing it.
Maybe we could do it this way. My proposed edit begins at line 96 on page 3. So maybe we look at conclusion of law 22, the amendment that I'm proposing at line 96, and use that as a departure point for any additional conversation.
That's what I did. Is I finally compared the wording from mine to yours, and they are the same. So I apologize. I got confused in my head, but what I had, what I would propose in my motion appears to be the same language of what you would propose, amending conclusion of law number 22 by adding the sentence that you have. So I apologize. I got confused on my end.
Yeah, that's all right. There's ample opportunity for confusion on this item. Bobby?
We've all grabbed this elephant by multiple body parts. I think I'm in agreement with both of y'all.
Okay, so
I've looked at that language as well. I think that's certainly appropriate to add on amending conclusion of law number 22.
All right, appreciate that. The next edit that I think we need to do to accomplish this is at ordering provision 1 again, and Commissioner Lindley, here we're getting back to the section 5, and this is at the top of page 4, lines 126 and 127. you'll take a moment to take a look at that and see if we're in agreement on those edits.
I'm in agreement.
I think I am as well.
All right, I think that wraps up the discussion of issue 7, and let's move on to issue 8. Bobby, I'm really enjoying your elephant analogy. I think that's very appropriate here. All right, on to issue 8. Here, I agree with the ALJ's findings and conclusions that the application substantially satisfies the requirements to specify the project timeline. So I don't see any deficiency here, and I would not propose any changes to the order on this issue 8 relating to the project beginning date and completion date and timeline.
I'm in agreement.
I'm in agreement as well. I'm now second guessing and wondering if these are provisions or language that we've made revisions to with other suggested revisions in previous discussions. But I agree with your read of this PFD issue, and I agree with you that there are no changes warranted for that substantive item.
Yeah. Okay. Well, I think that resolves issue 8, but let me now return to your observation, Bobby. The language in the ALJ's proposed order, or the edits to the language, they're overlapping because the issues are somewhat intertwined. Several of the issues point to a future amendment process that I'm suggesting that we discard, and which has effectively been discarded in the edits that we've walked through. What I'm going to suggest when we get to the end of these issues and before we take a vote is that we just pause and take whatever time we need to digest that proposed change document in its entirety, because it's going to form the basis of the motion. But at this point, we have actually addressed all of the lines in that document. Is that helpful?
I think I follow now. And because of that interlinking substance of some of these issues, we've touched on the same change resolving multiple issues from different directions. I think I'm in agreement, but I'm very comfortable with your proposal to take a little time to digest it. So thank you for that.
Yeah, okay. Yeah, so in some instances, we double deleted things, for example, and in others, I may have just mentioned an edit once where it really goes to multiple issues. But we're going to take our time with this before we take a vote and make sure we're all satisfied with it. But let's get back to the issues and wrap those up. Issue 9, I have no basis to upset the ALJ's findings that the application complies with the Coastal Management Program. I don't have any issues with the CMP, so I would propose no changes here. Commissioner Lindley, how'd you come out on that?
I came out the same way. No changes.
Commissioner Janeka?
Likewise, the very same.
Similarly, on issue 10, I don't have any basis to disturb the ALJ's apportionment of the transcript costs. Any objection, Commissioner Lindley?
No.
Commissioner Janeka?
No,
okay.
Thank you.
All right. So I want to ask two things. Have I missed anything? Did I address all of the concerns that you may have had? And that's first. Second is, let's take some time to allow you time to work through this proposed order changes for item 1 document and make sure you're comfortable with it. And then once we answer those two things, I would be prepared to make a motion. Should we take another recess? Would you like to just? Yeah. Okay.
I would. Yeah.
And
I need at least 10 minutes. I'll say it that way because I'm going to try and I thought I could do this all by screen, but I need to print your document and kind of put it side by side to mine, and so.
Yeah, and then the other complicating factor is you got to have the ALJ's proposed order right there.
Yes.
So it's a lot of paper to flip through, and I really appreciate you guys hanging with me through this. It's a difficult task, but I thought you did really well actually at following along. So, all right, Commissioner Janetka, a 10-minute recess sound good to you?
Absolutely perfect.
Okay. All right. So I've got 11:21, and we'll stand in recess until 11. Actually, I've got 11:22. We'll stand in recess to 11:32, and we are in recess. All right, well, welcome back, folks. It's 11:33. We're back in session after a short recess and looking at the proposed order changes for item 1 document and considering whether there are any other remaining issues for us to discuss. And Commissioner Lindley, let me begin with you. How are we doing?
I think we're good. I think what I would say in my motion is in step with yours, so I don't have anything to dive into on what you prepared. I think I'm fully in agreement, and sorry for the confusion earlier. I had to dive into that real quick, but yes, we were saying the same thing on referring to the ALJ's proposed order. I'll stop there.
Great. Thank you. Commissioner Janeka?
Dove into and pulled myself out of the mud on some confusion of my own. I think my concerns about special provision 6I, how that answers some of the other PFD issues. Ultimately, our order today is leaving that special condition in the original draft permit, and we're removing proposed changes by the ALJ to that special provision. So I think I'm all comfortable and appreciate your walking us through all the changes, Chairman. This is a tricky matter. I want to commend ED staff and just I'm blown away yet again by what our agency engages with and works on and the scale that we do it in terms of the number of years. Lead time for projects, water projects going over a decade, make me feel a little bit better when it takes our agency lengthy time for reviews. But diving into this level of detail, I think this hopefully helps remind us all where it's important to make sure we're crossing our T's and dotting our I's. So thank you.
Thank you, Commissioner Janeka. I discovered a little wrinkle that I just want to speak to, and that is that I think the line references that I was giving you may, in a couple of instances, been off by 1 or 2 lines. It appears that that when we converted the Word document that I was working from into the PDF, that it may have reformatted the line numbers ever so slightly. They are one and the same document, but my references were just ever so slightly off by a line number or 2. Doesn't affect the substance of the document. So, colleagues, with that, I'm going to move that we grant the application of the Guadalupe Blanco River Authority for water use permit number 12378, that we issue the ALJ's proposed order with the modifications listed in the document titled Proposed Changes for Item 1, which has been discussed today, which has also been provided to the Chief Clerk's office, and which was published to and distributed through today's webinar. And I further move that we issue water use permit number 12378 consistent with those provisions and modifications.
I'm comfortable with seconding that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
I am here. Just a moment. Item 31 is the public comment session. We currently have no one signed in to address the commission, but we will unmute the webinar for a moment and give those on the line a chance to let us know if they would like to address the commission. Hearing no one, I will move on to our next items. Items 32 through 35 are for closed session, and the commission will not meet in closed session today.
The time is 11:38, and we are adjourned.